So this is the contract of sales of goods, 1930. This contract is talk about the transaction in the nature of sales of goods from the subject matter of sales of the goods, Act 1930. The Act came into force on 1st July 1930. It was accepted in whole of India except Jammu and Kashmir. This Act is having two elements. First is the sale and another is the agreement to sell. Many of the time students are having confusion in their mind about these two terminology. They are not able to discriminate these terminology. So in this video, I would like to talk about sale separately. Then I'll be talking about the agreement to sell separately, so that you will be able to understand the difference between these terminologies. Once you will be able to get the difference between these terminology, you would be able to understand the concept behind the contract of sales of goods. So it's very, very important to know the difference between these two. Sale. What is sale? Sale is executed contract. Please pay attention. Sale is executed contract where the property in the goods is immediately transferred from the seller to the buyer. From the seller to the buyer. The contract is called as sale. So sale is a process which involves the immediate transfer of the goods to the buyer. So this is the sale. Agreement to sell is the executory contract. Agreement to sell is the executory contract. Executory means which will be executed in future, where the transfer of property in goods is to take place at a future time or subject to fulfillment of certain conditions. The contract is called as agreement to sell. So basically, sale is the executed contract and this is the executory contract. It is finished in the present time and it will be finished in future time. So basically, immediate transfer of the property, transfer of the ownership is the sale, and agreement to sell is in the future reference. So you can see the definition of contract of sales of goods. According to section 4.1, it is defined as contract of sales of good as a contract whereby the seller transfer or agrees to transfer the property in goods to the buyer for a price. Please pay attention on these two words. Seller, transfer, or agrees to transfer. Both of the point. Transfer means sale and agrees to transfer means agreement to sell. So basically, the contract of sale governs two small terminologies or two sub-concepts. One is the sale, another is the agreement to sell. So this definition also covers these two elements. A contract whereby the seller transfer or agrees to transfer the property in goods to the buyer for a price. So basically here seller is transferring a good to a buyer, and in return buyer is giving price to the seller for the same commodity or the goods. These all are the essentials of contract of the sale. First is there should be the involvement of two parties. Of course, if there is a contract, there will be at least two parties. There will be the involvement of two parties. One party has to act as a seller, another party has to act as a buyer. Single party cannot play the role of seller and buyer both. Second element is the subject matter of the contract must be the good. If we are talking about the contract of sales of the good, so definitely there should be the transaction of goods. Third is the price. Seller is selling his commodity to the buyer. In return, he must be getting the price for the same commodity. So that is the contract of sales of goods says. Transfer of general property. Of course, there should be the transfer of property from seller to the buyer. In return, buyer is paying price to the seller. So these all are the essentials of contract of sales of good. So let me discuss each and every element in detail. So this is the first element, involvement of two parties. As I earlier said that there should be the involvement of two parties. One has to be the buyer, another person has to be the seller. So single person or single party cannot play the role of both. Second point, transfer of general property. The object of contract must be the transfer of general property as distinguished from the special property in the goods by one person to the another person. The term general property refers to the ownership in the goods. So basically, second element says there should be the transfer of property. There should be a transfer of ownership for the property. So that will comes under the sales of goods. Like if one party is giving a good to the another party for a certain purpose or for its use, so that will be the bailment. The person who is transferring the possession of good is the bailer, and to whom it is being transferred is the bailee. This is the contract of bailment. That will not be the contract of sales of goods. So if we are talking about contract of sales of good, there should be the involvement of two parties, and there should be the transfer of general property. So there should be the transfer of ownership also. This is the third point. The subject matter of the contract must be good. Of course, the contract of sales of good is dependent upon the transfer of good. Good means, what is good according to the contract of sales of good? That is written over here. Goods means every kind of movable property. Every kind of movable property. Rather than actionable claim and money. And include stock and share, growing crops, grass, and things attached or forming a part of land, which are agreed to be removed before sale or under the contract of sale. So here clearly mentioned that goods means movable property except actionable claim and money. So we are not including actionable claim and money in goods according to the contract sales of the good. So what is actionable claim? Let me explain you in a single line. A claim which can be recovered only be means of a suit or an action in a court of law. On an action in a court of law. So this is the actionable claim, and actionable claim and money would not be considered under movable property, except these two. Movable property will be counted in goods according to this contract. So essential 4, price. This contract says that if a person is selling his good to the buyer, seller is selling his good to the buyer. So buyer need to give the consideration, and consideration will be only the price. The consideration would not be the good. If it is good, then it is not contract of sales of good. That will be the barter transaction. So you can read it out in the slide also. This is the slide where I'm going to talk about the formation of contract. So how this contract is formed, except few special cases. No particular form is necessary for entering into such a contract. The agreement may be expressed or implied from the conduct of the party. It may be formed in following ways. So except few special cases, there is no particular format given under this contract on which there should be the formation of contract of sales of goods. So the agreement may be expressed or implied. This agreement may be expressed or implied. This may be formed in following ways. First way, there may be immediate delivery of goods and immediate payment of money. I have earlier told you that the contract of sales of good is depend upon two party, buyer and seller. Seller is delivering his good to the buyer and buyer in return to his good giving money to the seller. That is the consideration. So if both of the exercises, delivery of goods and payment of money, these two are the exercises. Delivery of goods and payment of money are with immediate effect. If both exercises are immediately performed, so there is the formation of contract. There may be the formation of contract. This is the one way to having the valid contract of sales of goods. Second point, it may be agreed that the delivery or payment or both are to be made in installment. So maybe the first element, delivery of goods, or the other element, payment of money, or both of the element, delivery and payment both, are paid in installment, are performed in installments. Definitely this is also the valid way to form this contract. Third, it may be agreed that the delivery or payment or both are to be made at some future date. If both of the party agreed upon that the delivery of goods or payment of money or both of means the delivery of goods plus payment of money are to be made at some future date, means the delivery of good would be in any of the future date, or the payment may be done by the buyer to the seller on any future date, or both of the things, delivery of goods plus payment of the money will be done on a future date. So again, this is the third way to make a valid contract of sales of goods.